Hello again, this is Miss Joe, and today I'm going to be covering more of our First Amendment civil rights and civil liberties, but specifically looking at everyone's favorite freedom of speech. So I have this quote here. Students do not shed their constitutional rights to freedom of speech and expression at the schoolhouse gate. So this is actually from a specific case, but I'm going to talk about that on the next slide. So one thing I'm going to get us going with is this idea here, and it definitely has come up often now in the digital age as well, with students free speech or exercising their free speech on social media. And I will say typically the law takes longer to catch up than society and culture. But thinking about this, are there limits to students' right to free speech? What would they be and why? So this is certainly a discussable question. I'm sure each of you has your own opinion. I'd love to give some time for you to talk about that in class. But for now, since I'm recording and I don't want these to get too long, I'm going to move forward. So, again, today we're talking about freedom of speech. And this is definitely one that has evolved over time, maybe even more so than some of the other pieces. This is a cornerstone of our democracy, right? In order for a society to feel or to be truly free, right, you have to be able to express yourself freely. However, that does not mean that there is absolute expression. We might compare this also, to a totalitarian government where there is not freedom of expression. So you're always playing with that push and pull. But then, do we allow for absolute freedom of speech? Um, and then there are different perspectives on this. This is something that was happening recently with Elon Musk and Twitter, right? So his perspective is one that, any person should be able to say whatever they want to say without any restrictions. Now there are people on the other side of the fence that would say that is also harmful, right? Um, and then I'm going to talk about, in one of those cases, you've probably heard this before, the you can't yell fire in a crowded theater, right? So, or bomb in an airport, that speech is inciting danger or harm. Sometimes I point out to students, if we're talking about a murder case and you convince somebody else to murder somebody else, right? You can think about what's his face? I was gonna say Marilyn Manson. That's not it. You'll figure it out. I'm drawing a blank here. But he actually never killed anybody, right? So, but his speech, his words did cause violence. So he is responsible for those murders. So in that case, we can look at that too. You can't just say whatever you want. And this is a tricky topic for sure. Um, Another piece that's important on this, because obviously it's something that comes up in our world often, is this idea of hate speech. And so, you guys were living in Europe right now, and hate speech is a lot more regulated than it would be in the United States. And so, you can probably make some assumptions on why that is. I used to live in Germany, and there's actual legislation regarding, what you can say and cannot say. If you are a Holocaust denier, that's technically illegal, right? So that's something that society has established as a dangerous speech. Like, you cannot say that because it leads to perhaps violence or harm to others. And so those are obviously very clearly aftermaths of World War II. But I'll move forward. Or will I? And so ultimately, we're going to be looking at Supreme Court cases that have challenged this particular element within our society, and specifically within the First Amendment. All right. So our first one is Tinker v. Des Moines Independent Community School District. This is 1969. This is also a very famous case. You might have heard of this before. It's something that's used a lot to protect student free speech. So going back to that initial question, what are students' rights in terms of freedom of expression? This is kind of funny. I'm going to show us a little picture here of our rabble rousers. These are the students that are causing all of this trouble. Look at them. Oh, you can just tell they're up to no good. But ultimately, here's our facts of the case. So these were students that came to school with armbands. They were protesting the Vietnam War. They were suspended. Um, and this one is also interesting because we're talking about this concept of symbolic speech, because they're not actually talking, right? They're wearing these armbands, and this is to be interpreted as speech through symbolism. So they got in trouble, and then ultimately it did rise to the level of the Supreme Court. It was a hot topic, right? Student protests of the time. Where do we draw the line on the good of the colony, right? The good of the institution and student free speech. Um, so ultimately, the decision is that yes, they did violate, or the school did violate the First Amendment, that the students are allowed to participate in that symbolic protest, and that it did also violate their freedom of speech protections. And then this is a really, really important one. I'm going to get fancy and use my pen. Orange. Okay. May not restrict speech unless it causes a substantial substantial disruption. Excuse me. Um, that was not pretty. But when we're talking about this substantial disruption, this is super important because that element of this decision is what is used as kind of a litmus test for basically all of these cases, even still and yet to this day. I've talked with my administrators, and they're all aware of this case. Like when any kind of student issue comes up, that's what they're thinking of. It doesn't actually have to get to the level of the law or the courts, but it's like, wow, is this going to cause a substantial disruption? So this is actually very relevant for anything that you're doing in the school at all. Dun, dun, dun. Get rid of that. Okay. So then our next case here, and this is a little funny. Um, it looks like you want to pronounce it as shank, but it's actually skank. I know, great name. Skank versus the United States. I want you to notice the date on this one, 1919. So this is, instead of we're looking at Vietnam, and then we were looking also legacy of World War II, this is actually World War I. And so here now it comes into play that balance between what's going to be good for a group, the social order, good for the whole versus the individual. And this is also the introduction of the time, place, and manner test. So this is kind of how we break down these ideas here. And this test has been implemented by the courts basically to determine if the freedom of expression in question is protected under the First Amendment or not. So in the first one, we must not suppress the content of the expression. So that's really important here, the content. Another example besides the Skank versus US that we're going to talk about is O'Brien versus US. Is burning the draft card, a disruption? And so in that case, like, yes, it is a disruption because it prevents the government from potentially raising an army in a time of need. We're also looking to see we're also making sure that the law is designed in the most specific and targeted way possible. We want to make sure that there's not going to be any spillover. And then ultimately the court can suppress expression on the basis of time, place, and manner if there are other times, places, and manners in which the idea can be expressed. Um, so I'm just going to give you some other cases, that you could look at that represent this particular test as well. So it's going to be Cohen versus California, 1971. He was wearing a jacket with the words F the draft into an LA courthouse. This is actually deemed protected. The one I just mentioned, O'Brien versus US, 1968. This was the burning of draft cards to protest Vietnam. This was considered not a protected right. And then another very famous one, Texas v. Johnson, 1989. And then US versus Eichmann, 1990, burning the American flag. This has been protected, upheld several times as well. So those are just some cases that you can look at too, or should be aware of in terms of how this might show up, or how this has shown up, at different times. But I'm going to move on to types of unprotected speech. And then I just wanted to point out my little picture here, just as a reminder when we're talking about libel is a printed statement, whereas slander is spoken. So those get thrown around quite a lot, but I like for students to be aware of the difference of those. So in this case, when we're talking about defamatory speech, it's rarely declared unprotected speech. A libel or slander case must be quite extreme for the suing party to be rewarded damages, especially if we're talking to politicians. I know most of you guys are probably well aware of the Johnny Depp, Amber Heard cases recently that had to do with libel and slander. So I know some people were like, oh, Johnny Depp won. Actually, they both kind of won and lost because they both had to pay damages. So those are interesting. You can see how it works in kind of on the popular culture side as well. I want to point out some other cases that have to do with libel, so printed statements. New York Times versus Sullivan from 1964, and Hustler versus Falwell, 1987. All right. So now we're going to dig into good old Skank versus the US. So ultimately, we have our facts here of the case. Where am I? Dun, dun, dun. So Skank was circulating these flyers. He had said that the draft violated the 13th Amendment, and he was equating it to slavery, right? Because it's something that's against his will. And remember, this is happening during a wartime. So they're asking then, did Skank's conviction under the Espionage Act, right? So he was actually convicted, and they used Wartime Act in order to follow through with that. Did that violate his First Amendment? And ultimately, the decision was no. They said that it didn't violate the First Amendment because we're talking about wartime. And this is where that clear and present danger comes in as well. Let me get my little handy dandy pen. Dun, dun, dun. So this is where the clear and present danger precedent comes from, and that has shown up several times. So if you're thinking like, I've heard that before, this is where that comes from. That's also it's not it's to a lesser degree. We can think about wartime internment of Japanese Americans, that along similar lines of thinking of like, yeah, well, because it's wartime, this is something that we have to do because of that clear and present danger, um, not quite the same, but notice how what's happening in a society at that point in time is impacting, how these cases are being interpreted, even though we're using the same documents, the same amendments, right? That is going to change, and that's part of why it's such a great piece of writing, because it is flexible in that way, whether or not you agree with the actual decision. All right. Let me see. Moving on. And that's it. That's all I got. Kept it under 15. Okay. Let me know what questions you have, and I will get to you as soon as possible.